There's without doubt probable cause for a felony theft of $3,000.
I was wrong. Please don't take me to jail.
It's a felony.
I really can't go to jail.
I
I'm a single mom.
The only thing I would definitely be cognizant of is that this is a felony.
On January 8th, 2023, Palm Beach County Sheriff's deputies responded to a Burlington store after loss prevention uncovered an alleged employee fraud scheme. Investigators said a cashier repeatedly suspended transactions, allowing roughly $3,100 in merchandise to leave the store without payment.
Oh, yeah.
Somewhere around down there. Yep.
Good. So what's going on?
She was always the cashier. Like, she was always giving them the stuff for free.
Okay.
You know, the other associates, I haven't found any where they're picking her up. She's just the cashier, so she's really admitted to like $3,000, which is about what I came up with. So a minimum of $3,000 she allowed to leave the store by not properly ringing it. But I put it on here, like I kind of put, this is her, so she's responsible for, let's just say, $3,000. The other one, from what I can see on the transactions, 16 of that is what this associate walked out with. And this one here is like a former associate she recently quit. That's just their names. I just had all the other associates' names.
But that person you have prison here today, she was involved in all the transactions.
She was involved in all. She was the cashier.
So she was the cashier. So she was like letting the employee leave with all those stuff.
She would ring some of the stuff up, or look, so it looks, if anybody's looking, it looks like everything's getting rang. But then instead of cashing it out, they would hit suspend, so it just suspends the transaction. But she still gave them the stuff, and they walked out. They never paid for it.
Like on this here, that's every one of these are items taken, or
None of that was paid for.
Okay, that's why I just want to make sure.
Yeah.
It's almost 3,100.
This is her generic statement.
Yeah, but it's not sworn to us.
No, I didn't know if you needed it.
Give me 1 second, all right? Well, let me go in and talk to her. Or at least let me make contact with her over what's going on. I'm sure they could be outside her.
He's here to talk to you.
All right. I'm Deputy Frankie with the Sheriff's Office. Well, unfortunately, there's no choice. You're going today.
Can I pay the money back, please? I can't go to jail. I just off my grandma and everything. I can't go to jail.
You got $3,100?
I can pay payments. I can do something.
That's not on my hands. That's on them. But they want everything right now. They're prosecuting.
Can I please make payments? I can't go to jail. I just off my grandma this morning. I can't.
I know, that's awful. I mean, I can't, like I said, I go with the corporate.
Please, I can't go to jail. I really can't go to jail. I'm a single mom. I can make payments. I can do a payment plan. Please just talk to them. I can't go to jail.
Right, and I did this. I know it's tough, but I did, and they, it's.
Please, can you call them back and talk to them and explain to them? I can't go to jail, sir. I
will call them back, but I don't know what it's going to do.
Please, just talk to them. I can't go to jail. I can't.
I will call them, but just talk to this guy.
He gonna take me to jail.
Well, first we're going to talk, and then we'll go from there.
First, and just. But I will go step out and call. But like I said, I did tell them all that ahead of time.
I can make payment plans.
Based on,
I can do anything. Just tell them, please don't take me to jail.
I understand.
I was wrong. Please don't take me to jail.
Okay.
Please.
We'll talk to this guy. All right.
All right. What's your name, ma'am?
Yes.
All right.
The deputies are inside a private store office with management's permission, so no warrant is required simply to enter that workspace. The legal situation changes when the cashier is told that she has no choice and is going to jail. At that point, a reasonable person would no longer believe that she was free to leave. Legally, the encounter has become custodial. Her earlier apologies and emotional pleas may remain admissible if they were genuinely spontaneous and were not prompted by police questioning. But from this moment forward, any questions designed to produce incriminating answers require a constitutionally sufficient Miranda warning. And in this encounter, the deputy's exact wording will become extremely important.
So, I'm going to read you Miranda because we are going to talk. So, just make sure you acknowledge everything that I say, alright? You have the right to remain silent and not answer any questions. Do you understand?
Yes.
Any statement must be freely and voluntarily given. Do you understand? I just need a yes or no.
Yes.
Okay. You have the right to an attorney of your choice or a court-appointed attorney before you make any statement or any question. Do you understand?
Yes.
I can make no promise to induce you to make a statement. This must be in your own free will. Do you understand?
Yes.
Any statement can and will be used against you in a court of law. Do you understand your rights so far?
Yes.
Okay. Do you want to speak to me what happened? Because we got a lot of stuff here. So, would you like to talk to me about what's going on, or?
Hello? I was wrong.
I'm sorry?
I was wrong.
Okay. Well, I mean, I know you've spontaneously uttered that a few times. What I'm getting at is, okay. So, we have all these transactions that were not rung up. Okay. You with me so far?
Yes.
And some of these were for employees that work here, correct? Okay, so do you want to explain, like we have one that's on layaway, like what happened? What happened here? I mean, did you ring it up and just let them walk out and not pay for the product? Is that what's happening?
You.
Okay. And he's going to call corporate, so nothing's official yet, but we are going to talk, because... So they say about almost $3,100 in items so far.
But like I don't even know half of them people. I told it might was a mistake for some of them, but they're saying that the receipt came out after they put their card there, and the receipt came out. I didn't know if I suspended or not. I just explained that to them. Some of them people I don't even know.
Oh, explain. I don't understand what you mean by suspend. That's what I don't understand. What does that mean? So, like this one here has your name, right?
Yes.
So this was a transaction for 13 items on the 28th, right? So, and it says status suspended. What does that mean?
The transaction was suspended.
Okay, was that a declined card or?
Let me see what it was. No, it just was. I just canceled the whole transaction.
All right, so you suspended that transaction, right? So your end of the day count is not looking for that money because that transaction was suspended, correct? So we have a total of it's like $103. So did you allow the product to leave the store?
Yes.
Okay, and did you know that the transaction was suspended?
Yes.
Is that something you?
It's the one. No.
This is what it says.
One person used the card. She put her card in, but the receipt still came out. He said I put suspended, so the receipt still came out. So he said I suspended it, and the items did leave the store.
Okay, so the transaction was suspended. You knew it was suspended. And
not this one. It's another one that I knew was suspended.
Okay, so regardless, how does it go in suspended? Is it because the payment wasn't accepted, or there was no payment, or is it something you have to do?
You can press F. You can press your number on there and it's suspended.
Okay, so that's happened, and so you knew that this transaction was suspended for whatever reason, and you allowed the product to leave? I'm sorry?
Not on all of them because the receipt will come out. If they put their phone right there, it won't tell me if you want to pay. It's just the receipt will come out.
Okay, but does it always have suspended? I mean, every one of these receipts has suspended on them.
That's what the system said.
Okay, and I also have one here, I'm looking for it, that was a layaway, that they came back in the next day, that layaway was then canceled, and then the product still left the store.
Yes.
So I guess what I'm getting at here is, I mean, you're knowing allowing this stuff to leave the store, correct?
The layaway, yes.
So why would you do that?
I told her I was helping a person.
Are you getting any kickback for that? Are are they giving you anything for this product, or and how long you work for Burlington?
I started in March.
In March?
Yes.
Because they also got video, which they're going to provide us for all these transactions. So, I guess another question is, how do you pick and choose who you're allowing to leave without paying for product? Because some of these are associates that work here.
Two of them are.
Two of them were definitely associates that we know of. Is this something they do that they told you about? Because, I mean, they coming up to you asking, I mean, do you know them from like, the neighborhood? I mean, how do you know them? Are they just, other than work?
Two of them work. One of them I know.
That works here?
Yeah.
Do you know them prior to working here?
Yeah.
And then did they tell you that this goes on?
No.
You ever been arrested before?
No.
You ever been in trouble?
No.
Alright, I know he's talking to some people, but as of right now, if this goes the way it is, it's a felony. You will have to if they do decide to prosecute, it's up to them. They could turn around and be like, we'll work something out with you. I have no control over that. If they do, the only thing I would definitely be cognizant of is that this is a felony. So they have a certain amount of time that they can report this without any repercussions. So if they decide to work out a payment plan, which I have no control over at all, and you fail on that payment plan, they can call us right back. And with everything I have here, and after speaking with you, there's without doubt probable cause for a felony theft of $3,000. So if that's something that they allow to happen, again, I have no control. Then it's something that you need to stay with, because there's enough here. I mean, there's $1,000. You could almost be charged with a scheme to defraud. If you're working with other people to defraud Burlington, that's another charge on top of it. It's not just a theft of $3,000 because you didn't keep the product. You don't have it. You allowed it to walk out. So there's a charge on the books. It's called a scheme to defraud, which is you're facilitating it and other people are benefiting from it. Because you're not benefiting. You didn't get any of the product. It's not like it's sitting in the car waiting for you to get out, unless you all are taking it and reselling it on the outside. I get it. Listen, times are tough, right? I get it. Trust me, I understand that. But you also have to understand too that you're not talking a couple hundred. It's $3,000. You've been here since March.
Yeah.
Yep. That's what I thought.
Yeah, never prosecute.
Okay.
The interview is now unquestionably custodial. The deputy informed the cashier that she could remain silent, that her statements could be used against her in court, and that she had the right to an attorney of her choice or a court-appointed attorney before making a statement or answering questions. She repeatedly confirmed that she understood those rights and then began answering questions. Under the United States Supreme Court decision in Berghaus v. Tompkins, this conduct can establish an implied waiver, provided that the Miranda warning was complete, understood, and free from police coercion. But the audible warning creates a legitimate suppression issue. The deputy never clearly states that the cashier has the right to have an attorney physically present during the interrogation. In Florida v. Powell, the Supreme Court explained that officers do not have to use one precise script. However, the complete warning must reasonably communicate that the right to counsel continues throughout questioning. In Powell, the suspect was also told that he could exercise his rights at any time during the interview. No comparable statement can be clearly heard in this footage. A court would therefore need to examine the complete recording and the deputy's exact words before declaring the warning constitutionally sufficient. The cashier's emotional distress does not automatically invalidate her waiver. Under Colorado v. Connolly, emotional or psychological distress alone will not normally make a statement involuntary. Some form of coercive police conduct is generally required. The footage does not show the deputy promising leniency in exchange for answers. Nevertheless, her statements made before Miranda must be separated from her answers during the formal interrogation. Genuine spontaneous statements may remain admissible, while answers produced through custodial questioning depend on the validity of the Miranda warning and waiver.
Well, we're gonna have to, I am going to be cordial, and I'm gonna respect you. We're gonna get everything we need from him. We're gonna walk you out like normal. So you give us any indication that you're not gonna cooperate, you're going in cuffs. You're gonna go in cuffs at one point, but instead of what they call perp walking you to the store and embarrassing you in front of all these people, we can do it cordially, and then we can go outside, because this isn't gonna be you get released or you're gonna go to county. So you're going to buy that. I mean, if it was a misdemeanor, I could release you on scene. I can't. This is $3,000. I can't do that. So you have to. You're gonna have to see a judge. If you ain't got no rec.
Stay the night in there?
What's that?
I gotta stay the night?
It's a felony. If we don't get you down there quick enough, yeah. I can't undo that. But if you got a good record, no history, you know there might be an ROR. That's up to the judge. Where do you stay at? Okay, so guess what? I'll take you out there. All right? Because I can take you to Gun Club, which means someone got to come all the way over here to Coast to get you. I can take you out to the Glades, which is where we're supposed to take you. And then when you get out, you're right there. All right? I'm going to do as best I can. As long as you cooperate with us and be cordial, then we can work. And he's with me. We can take care of this. But if you start acting up, cuffs and all the way through. All right?
Where's your purse?
In the locker.
All right.
In her vehicle.
All right.
She's got what she wants out of it. So if you want to go back to the sub with me and help me do the property real quick.
All right.
And then we can get her down where we gotta go. Like I said, man, if you cooperate, let's go this route. If you don't,
Well, you want to leave your stuff in the car?
to the bag.
All right.
She's gonna take a couple items that she needs and the rest of them. Show us where your car is. One of us will take that out there and drop it off. Once you go to my car, we have to go in cuffs, and then we'll give you I'll double them up. And then we'll transport you to our district to do our paperwork. We're not gonna do it here in front of the store.
This is the black Impala.
What's that?
It's the black Chevy
This
Impala.
black Chevy Impala.
All right.
All right, you want to get that in the keys? This is me right here. We'll try and make it as comfortable as we can, right? It ain't built for comfort. Hold on, we got one. We're gonna double it up, which will give you a little bit more freedom, all right?
The arrest appears to be supported by probable cause and did not require an arrest warrant. Florida law permits an officer to make a warrantless felony arrest when the officer reasonably believes that a felony occurred and that the person being arrested committed it. Management's account, the suspended transaction records, the surveillance recordings said to exist, and the cashier's answers during the interview collectively satisfied that lower pretrial standard. The most direct potential charge is grand theft in the third degree under Florida Statute Section 812.014. To obtain a conviction, the prosecution would have to prove that the cashier knowingly obtained or used Burlington's property with the intent to deprive the store of that property or to appropriate it to people who were not entitled to receive it. She did not need to carry the merchandise out of the store herself. Under Florida Statute Section 777.011, a person who intentionally aids or facilitates a criminal offense may be prosecuted as a principal. If the separate transactions formed one scheme or continuing course of conduct, Florida law permits their values to be added together. A proven value of approximately $3,100 would fall between $750 and $5,000. That would place the alleged conduct within third-degree grand theft. Organized fraud under Florida Statute Section 817.034 is another plausible theory. For that offense, prosecutors would have to establish a systematic and ongoing course of conduct, fraudulent intent, and property obtained through the scheme. When the property is valued below $20,000, organized fraud is a third-degree felony. Grand theft and organized fraud may be filed as alternative charges. However, Florida double jeopardy precedent generally prevents a defendant from being convicted of both offenses when both convictions are based on exactly the same criminal conduct. A potentially more serious theory existed under Florida Statute Section 812.014, subsection 6. In 2023, that provision made it a second-degree felony to coordinate the activities of one or more people in committing theft when the stolen property exceeded $3,000. The reported value in this case barely exceeds that threshold. Prosecutors would need reliable proof of the merchandise's value. They would also have to prove that the cashier coordinated the conduct of other people, rather than merely processing unrelated transactions or making individual register mistakes. A third-degree felony carries possible statutory exposure of up to 5 years in prison and a fine of up to $5,000. A second-degree felony carries possible exposure of up to 15 years in prison and a fine of up to $10,000. These figures represent statutory maximums. They are not predictions of the sentence that any particular defendant would receive. The defense could challenge criminal intent, the aggregation of the transactions, access to the cashier's register, the authentication of the surveillance recordings, and whether the store's receipt or payment process caused genuine mistakes. The defense could also file a motion to suppress the cashier's custodial statements if the Miranda warning failed to communicate her right to have an attorney present during questioning. Even if those statements were suppressed, the entire case would not automatically be dismissed. Properly authenticated transaction records, surveillance footage, witness testimony, and other independent evidence could still be used. Burlington could request prosecution and provide evidence, but the store did not possess final charging authority. The state attorney's office ultimately decides whether formal criminal charges will be filed. The police performance score is 7.5 out of 10. The deputies entered the store lawfully, developed a reasonable probable cause basis, used proportionate restraint, and handled the arrest discreetly. However, the ambiguous right to counsel warning and the suggestion that Burlington controlled the prosecution decision reduced the final score. The cashier's legal position score is 2 out of 10. This is not a moral judgment or a declaration of guilt. Her answers substantially strengthened the prosecution's potential case. However, the disputed Miranda warning, unresolved question of intent, incomplete transaction records, and unauthenticated surveillance footage still leave issues for the defense. First legal lesson: Miranda applies to custodial interrogation, not every conversation with police. Second legal lesson: genuine spontaneous statements may remain admissible even when they are made before Miranda warnings. Third legal lesson: probable cause can justify an arrest, but it does not establish guilt beyond a reasonable doubt. Fourth legal lesson: the value of separate thefts may be combined only when the prosecution proves that they were part of one scheme or continuing course of conduct. Fifth legal lesson: a victim's request for prosecution may influence the investigation, but the prosecutor controls the formal charging decision. Considering the evidence and the wording of the warning, did the deputies act lawfully overall, or did the Miranda advisement create a serious constitutional problem?